Hello, everyone. Welcome to Crime in Court. This is the Canton cover up series Commonwealth versus Karen Reed, and we are going to be talking about some new filings that have dropped today. This episode is titled Episode 112 Look the Other Way. CW caught hiding more evidence. So, you heard that right. All right, so let's get started. We've got multiple motions to get through. The first up, we're going to go over a motion from the defense to amend the court's scheduling order. So they're trying to buy some more time on some things because some new evidence has come to light. And we have an affidavit from Yannetti in support of that. And then we have the opposition from the Commonwealth, which we will read. And then, in addition to that, we also have the Commonwealth's opposition to the defendant's motion to dismiss. So we're going to see what Hank Brennan thinks of the defense's motion to dismiss, which we just read through last night on my channel. And these are brand new motions. So let's get into it. And please hit that like button if you don't mind. All right, so as I said, up first, we are going to go over the defense's motion to amend the court's scheduling order, which was dated February 10th, 2025. Now comes the defendant, Karen Reed, and respectfully moves this honorable court for an amendment to this court's scheduling order dated February 10th, 2025, as grounds therefore the defendant states the following. On February 10th, 2025, this court issued a scheduling order which sets forth that the hearing on defendant's motion to dismiss is set for either March 4th or March 5th. Yes, by the way, okay, so Karen is due back in court next week, Tuesday and Wednesday, and also Friday. So she's got a lot of things happening. They have to turn over their discovery, the reciprocal discovery, by Thursday of this week. So this is a very busy week. Plus, they have this motion to dismiss to actually argue, which is scheduled on the 4th and the 5th of March. So, what is that? Tuesday and Wednesday. We also have on Wednesday, I believe it is, the arguments in front of the federal court where they will be arguing her claim on double jeopardy. So that is also coming up, and then she'll be in. So that's in the morning of Wednesday next week, and then in the afternoon she'll be back in Canoni's courtroom supposedly, if this doesn't get changed, if Canoni doesn't reschedule it. But as of now, it is scheduled for March 4th and 5th to argue the motion to dismiss based on the extraordinary governmental misconduct. So right now, they need more time, is what they're arguing here. So the defense was informed late yesterday. Also, by the way, sorry to interrupt one more time, Turtle Boy has a hearing next week as well. He is arguing his motion to dismiss. Unfortunately, his hearing is scheduled at the same time of Karen Reed's hearing on Wednesday afternoon. I believe it's at 2 p.m. And that's going to be interesting because I don't know what's going to be televised and whatnot. Usually we get a recording of Turtle Boy's hearings afterwards. Sometimes we can listen live as it's going on. So maybe we will get that and hopefully be able to go back and watch video of that later because hopefully, or well, not hopefully, I think there's going to be some good arguments for, excuse me. Oh, I don't know what that was. Um, hopefully there's going to be some good arguments for Turtle Boy. to dismiss those charges of witness intimidation. That is what that's for. So I will report what I can on that as well. All right, moving on. So back to the defense's motion to amend the scheduling order. The defense was informed late yesterday afternoon, so February, so not yesterday because today is the 28th, but when they filed this, it was yesterday afternoon, February 26th, by Special Assistant District Attorney Hank Brennan. So what was that? Wednesday? Wednesday, they received they were informed, sorry, the defense was informed by Hank that the Commonwealth has additional discovery to turn over to the defense. Are you kidding me? So, after all of this BS that they just had to go through with Canoni this week in their hearing, now Hank is like, you know what? I got some more discovery for you. And they've already turned over their certificate of compliance for this trial because the reciprocal discovery is due, so that wouldn't be due unless they've already done that. And I believe they've done that a while ago, and then they had multiple discovery drops even after that. So they're still turning things over. They, according to Hank, they specifically have a chain of custody report relating to those Sallyport videos. You know, those things that Hank was like, we can't just create something that we don't have. Really? Maybe they tried to do that. I don't know. But we shall see whatever they turn over. So Tuesday, February 27th. So actually yesterday, today is what they're saying. Yesterday is when this was filed. But they're saying today, February 27th, Mr. Brennan confirmed that he expects to provide those reports by tomorrow, February 28th. So that is today. These reports may or may not get turned over today by Mr. Brennan, these chain of custody reports that have to do with the Sallyport videos. During this same phone call today, he further informed counsel that the Commonwealth will be producing Sallyport videos to the defense on Monday morning. So more Sallyport videos being turned over Monday morning, next Monday. It is unclear whether the videos will be produced. Oh, sorry. It is unclear whether the videos to be produced will be duplicative of what has already been produced or whether there is new material. So they don't know if it's new or what they've already received. It could just be him trying to confuse, distract. Maybe he doesn't know that they're all the same video already that they've received. We don't know. And they have not had time to see the material yet or review it. So how are they supposed to have, if it's not being turned over until Monday, how are they supposed to uh, go back in front of Canoni and for a hearing to discuss said evidence um, the very next day? I don't think that's fair. Plus, with the whole motion to dismiss and whatnot, that's another big chunk of time that's going to take away from the fact that they're actually trying to defend an innocent woman and they're going to trial in, I don't know, a month ish, a little over a month, and they're supposed to, what? Yeah, all these distractions, like it keeps taking them away from the fact that they are trying to prepare for trial. So it's not fair that the Commonwealth keeps coming at them and doing all this crap. So, new chain of custody reports, which the defense does not have as of this date and time of this filing, will directly impact the motion to dismiss and cause the defense to modify its motion to dismiss. So we know there's going to be an amendment or something coming for the motion to dismiss now. In light of this new information, therefore, the motion to dismiss is not yet complete. The Sallyport videos in the Commonwealth's possession that have been described as having been stored on the department's video file system. This new information will undoubtedly impact our written submissions and or oral argument. So they have things that they want to include that they didn't get to, and now they can add more to their egregious governmental misconduct type of motion there. So these videos, according to the Commonwealth, are not expected to be turned over to the defense until March 3rd. Again, March 4th is the motion to dismiss hearing. So how are they going to be able to prepare for that and be able to amend it in time? They can't. Considering the above, the defense expects to file a supplemental addendum to our motion to dismiss, but this obviously cannot be done until we receive the outstanding discovery. As such, we are requesting a continuance of the hearing on the motion to dismiss so that we can analyze the additional information, confer with our expert, and file an addendum to the motion to dismiss. The defendant respectfully requests that this hearing on the motion to dismiss be moved to some date after the production of this information, but no earlier than the week of March 17th. So they need time to prepare, particularly given the number of other critical deadlines that we are working to meet next week, which include satisfying all of our reciprocal discovery obligations, filing all motions in limine, and attending 4 separate hearings in relation to this case, 3 before this court and 1 in federal court. Do you think maybe the judge is potentially doing this on purpose? Or maybe, trying to, or maybe it's just her poor planning and desire to want to get it done so badly by April 1st that she just squeezes all these deadlines in right at the last minute where nobody has time to really do anything. So I blame Judge Gull. I mean, Canoni. I mean, Judge Gull has her own issues in Delphi. All right, so failure to allow Ms. Reed sufficient time to appropriately address and brief these constitutional issues with information contained in outstanding discovery from the Commonwealth that directly relate to the issues underpinning the motion to dismiss would violate her constitutional right to due process and a fair trial. So if you don't give her the time she needs to prepare for this, you are violating her constitutional rights. And therefore, she's not getting a fair trial. And will Canoni go for it and do this? I don't know. I'm thinking she's not going to want to change this hearing because it's going to have to force her to push the trial off further. When I don't think there's any way in hell that it's happening April 1st, especially with the federal hearing, the federal stuff going on, and yeah, I just don't see it happening. So we shall see. But anyways, Judge Canoni again still trying to, push forward with this deadline that is unrealistic. All right, so this is the affidavit of counsel in support of motion to amend the court's scheduling order. This is from David Yannetti. He says, I am attorney licensed to practice in Massachusetts. Yesterday, February 26th, 2025, Special Assistant District Attorney Hank Brennan called my cell phone at 4:21 p.m. I could not answer the call at the time, so I texted him with the promise to return his phone call. At 5:47 p.m., I called him back. He informed me that the Commonwealth would be producing a chain of custody report. He said that we would want it for our motion to dismiss, so he wants to get it to us forthwith. He said that we would want it, so he thinks he's being like helpful by saying, "Oh yeah, we got this chain of custody report. Finally, we figured that we found this, even though we should have given it to you years ago." This is just so incredibly frustrating and bizarre at the same time that this is happening. So I asked if he could give me a better idea of the time frame within which we would receive it. He said that he would like to have it by tomorrow. He would likely have it by tomorrow, today, February 27th, but that the sergeant responsible for drafting it is retired and it is unclear how long it would take him to finish the report. The sergeant responsible for drafting the report is retired and it's unclear how long it will take him to finish the report. So he does not already have a completed report. This is something that they're creating right now, apparently. He did say that he would definitely have it by the end of the week. I followed up with a phone call to Mr. Brennan today and we connected. He informed me that there would actually be two chain of custody reports, both of which he expects to produce for the defense tomorrow morning, meaning today. So hopefully the defense got that. He further informed me that he would be producing on Monday morning, the Sallyport videos. When I asked whether there would be new videos beyond what we already have, he replied that he did not yet know. Has he not like paid attention to what they're turning over and what he still hasn't and should turn over? Like, how does he not know? I think just saying I don't know is his way of just being ignorant, blissfully ignorant. All right, Monday morning is March 3rd, 2025. Oral arguments on the motion to dismiss is currently scheduled for March 4th or 5th. Until we receive both the chain of custody reports and the Sallyport videos, our motion to dismiss is incomplete. After receiving the outstanding discovery, we will need to analyze it, confer with our experts, and modify our motion to dismiss by filing the addendum. In light of the other deadlines we are working to meet in this case, including our reciprocal discovery obligations, the defense requires more time than 1 or 2 days to modify the motion to dismiss and alter its prepared oral argument. I believe it is in the interests of justice that the court to modify the court's scheduling order to allow the defense to orally argue its motion to dismiss any day during the week of March 17th. So he wants it rescheduled for the week of the 17th. What do you think the Commonwealth will say? They oppose it. Like, seriously, you could benefit from more time too, Hank. But no, he's got to oppose it just to be difficult. Commonwealth's opposition to the defendant's motion to amend the court's scheduling order dated February 10th. Now comes the Commonwealth and respectfully requests that this honorable court deny the defendant's request to continue the non-evidentiary motion hearing on the defendant's motion to dismiss for extraordinary governmental misconduct. In accordance with the scheduling order, the Commonwealth filed its opposition on February 27th. The Commonwealth objects to any continuance and will be prepared to address this motion on Tuesday, March 4th. But you didn't give any reason why. There is no good reason why you should amend, why she shouldn't move the hearing. There's this is all he wrote. Okay, good job, Hank. Good lawyering. You're really earning your keep there. All right, this next motion is titled The Motion to Impound the Commonwealth's Opposition to the Defendant's Motion. So here we're learning the Commonwealth is opposing the defendant's motion to dismiss, surprise, surprise, for extraordinary governmental misconduct. but he's asking for impounding the Commonwealth's opposition, yet we have it. Although there are redacted portions. So let's see what they say. The Commonwealth moves pursuant to Trial Court Rule 8, I want to say that is, Uniform Rules of Impoundment Procedure and its opposition to defendant's motion to dismiss for extraordinary governmental misconduct be filed under seal and impounded. Commonwealth's motion contains references to confidential federal documents which are restricted by a federal protective order. The protective order does permit disclosure to the Norfolk Superior Court for use in this criminal proceeding, provided that the court authorize the sealing and impoundment of the records. Furthermore, the Commonwealth's motion contains references to juror communications and quotations from impounded sidebar conversations. The Commonwealth moves for its motion to be impounded. Consistent with the public's access to judicial pleadings, the Commonwealth has produced a redacted copy of the motion. So we have the redacted. Why he's asking or wanting it impounded, I don't know if he wanted portions of it impounded or what, but yeah, I don't know. So he's asking for it to be impounded. We have it, but it is a redacted copy. Here is his affidavit in support of uh, the response to the defense's motion to dismiss. Um, Actually, let's read the opposition first. Sorry. All right, so here's the redacted version of the Commonwealth's opposition to defendant's motion to dismiss for extraordinary governmental misconduct. Now comes the Commonwealth in the above captioned matter and submits the following in opposition to the defendant's renewed claims and her indictments that her indictment should be dismissed because of egregious governmental misconduct. The Commonwealth disputes any ethical violations, of course you do, or misconduct, let alone misconduct that taints the legal system or infringes upon the defendant's right to a fair trial. Uh-huh. Sure. And we believe Hank Brennan because why? The defendant's motion should be denied. Dismissal as a sanction is very strong medicine and it should be prescribed only when the government misconduct is so intentional and so egregious. I would beg to differ that it is in this case, but Judge Bev isn't going to see it that way, so there's no point in even wasting your breath on this, but I don't know. It also kind of forces her hand a little bit to make a decision as to is she going to, make it is she going to finally dismiss it, which is the right thing, the thing that she should do, or is she going to continue on with this charade, which we all know what the answer is going to be there. All right, so dismissal as a sanction is very strong and appropriate only upon a showing of irremediable harm. Irremediable, yeah, I said that right. A showing of irremediable harm to the defendant's opportunity to obtain a fair trial. To the extent that the defendant has suggested that egregious circumstances might warrant dismissal, the Supreme Judicial Court has noted that we have never dismissed charges in such circumstances in the absence of prejudice. Judicial responses should be limited to truly remedial and not punitive measures. Well, but it is the only remedy after so much egregious misconduct is to dismiss the charges. And that's the point. But whatever. Hank. The Commonwealth does not dispute its prosecutorial obligations and constitutional duty to disclose in a timely manner material exculpatory evidence over which it has possession, custody, or control. Nor does the Commonwealth dispute its broad obligations to inquire and disclose any facts that would tend to exculpate the defendant or diminish her culpability and all statements of witnesses. The Brady obligation comprehends evidence which provides some significant aid to the defendant's case. However, to prevail on a claim that the prosecution failed to disclose exculpatory evidence, the defendant must prove that the evidence was, in fact, exculpatory. He's going to say that all of that stuff, the video of a clear video of Karen Reed's taillight, he's going to say is not exculpatory? Okay. Exculpatory evidence includes all evidence that tends to negate the guilt of the defendant or provide some significant aid to the defendant's case, and while rightfully broad, the conception of exculpatory evidence is not boundless. The Canton Police Department surveillance video. In 2022, the Commonwealth provided the defense with approximately 90 crime scene services photographs depicting the condition of the defendant's vehicle in the Canton Police Department's Sallyport. Yeah, the problem with that is that there were no pictures of it taken prior to it being pulled into the Sallyport and prior to Michael Proctor being by that tail light, which was hidden by camera and by inverting it and trying to uh, intentionally mislead the jury and the court. So, further provided to the defense was ring surveillance video of the defendant's broken rear taillight, right taillight, at approximately 5 a.m., statements of witnesses who observed the defendant's broken taillight around 5:30 a.m. Canton police cruiser video depicting the defendant's broken taillight at approximately 8 a.m. Observations of a damaged taillight at the Dighton Police and automated vehicle location data from cruisers who were assigned to the CERT team, evidencing that the CERT team was on Fairview Road before the defendant's vehicle arrived at the Canton Police Department. So CERT team at 34 Fairview Road before the SUV ever arrives at the Canton Police Department. But the CERT team never started searching until after her car had already been in that Sallyport. So, makes you wonder, huh? Lieutenant Kevin O'Hara of the Massachusetts State Police CERT team testified at trial, and his automated vehicle locator records confirm his arrival at 34 Fairview Road at 4:56 p.m. Lieutenant O'Hara additionally testified that his arrival was preceded by one other trooper from his unit, Trooper Jason Soleil, I don't know, at 4:54, so 2 minutes before Lieutenant O'Hara arrived. The defendant's vehicle arrived on the back of a flatbed tow truck at the Canton Police Department station at 5:30. So it arrives at Canton PD at 5:30. CERT is on scene at 4:54 p.m. The defendant has also repeatedly represented in the media and postured at trial that her taillight was broken at 5 a.m. when she backed into John's car by striking the victim's vehicle in the driveway of the victim's house. The Commonwealth has provided substantial evidence, including accident reconstruction video from its expert Judd Welcher. Okay, so that's a new guy. Judd Welcher is a Commonwealth expert. He's the new accident. He's the new Trooper Paul. He's the new accident reconstructionist. All right, so the Commonwealth has provided substantial evidence, including accident reconstruction video from its expert Judd Welcher, demonstrating otherwise. Beyond Beyond unsupported claims and vague innuendos, the defense struggles to establish how the condition of the defendant's broken taillight in the Canton Police Department Sallyport is in fact exculpatory or the most critical and highly contested issue of the case. That's using their words from their motion. It is because proving that cert, well, first of all, Michael Proctor lied about the time that he picked it up, so let's just back up there. Secondly, there were no photos of it ever taken. Third, I lost my train of thought. The highly contested Sallyport is, I lost my train of thought. Sorry. Um, I don't know where I was going with that. This happens to me often. I'm having a slow brain day. I don't know about you guys. My head, I had the flu and I just have not been able to shake this like dull headache. And it's just really affecting me and bugging me. So I don't know if anybody's medically trained out there. Why would I still have a dull headache that's been lasting for several days after the flu? And it's not like a sinus infection because I know what that feels like. So I don't know. It's just a dull headache and it makes my brain not work sometimes. So apologies. Um, but yeah, so Michael Proctor lied and all sorts of things. So, but that's where I was going with that, is that it proves, so Michael Proctor lied about it. There were no photos, and it proves then, if you can prove that cert wasn't there until after somebody they've had access to her car. Somebody could have transported taillight pieces there before they told CERT, before CERT was given the okay to start searching. And that's why it's so highly contested, Hank, because it proves a cover up. It proves planting of evidence to frame someone. That's why it's highly contested. And it is critical evidence. But he's saying, "Oh, it's not. It's not in fact exculpatory. Don't worry about that." All right. I'm glad I came back to my thought process. All right, so despite claims to the contrary, the defense never filed a motion to preserve or in its perpetual. Okay, the defense never filed a motion to preserve. Are you kidding me? We've actually gone over that. They did twice at least. So, um, how can he just flat out lie in his filings? I don't understand. But he's saying the defense never filed a motion to preserve, or in its perpetually evolving theory of the case, did the defendant specifically request prior to November 2024 surveillance video from the Canton police station? He's saying they never specifically requested surveillance video from the Canton PD. They don't have to. You should have turned it over anyways because this is part of an investigation into a homicide for this defendant, for you proving your case. Wouldn't you want it? If it does in fact show the things that you misrepresented to the court, wouldn't you want that to be out in the open? But because it's all a big fat lie, that's why we're here. All right, we have a footnote that says the defense claims their February 2nd, 2022 request for all evidence, all physical evidence, including anything present on or near the decedent at the time that his body was discovered, anything found at the alleged crime scene, was sufficient notice for the Commonwealth to preserve footage from the Canton Police Department. They had specifically lines in their motions for preservation long before this about not just the crime scene, but video footage, photos, anything that notes, police reports, all of it. They requested it all, and it was ordered to be turned over. The Canton Police Department is not the alleged crime scene. The Commonwealth could not reasonably have anticipated the defense's ever evolving third party culprit claims, nor to this day made the Canton Police Department video pertinent to their amorphous and fluid claims. So they're saying the defense's claims just keep changing and evolving over time, and the Canton Police Department didn't know that they were going to have this third party culprit thing. So we didn't know. Commonwealth didn't know. It's not our fault. We didn't know. Wow. Okay. Even though it is your fault and you're absolutely required to preserve that and turn it over to the defense, no questions asked. And you're not even, they don't even have to ask you for it. Like, it should just be turned over automatically. This is automatic discovery that should have been, but it was not turned over, unfortunately. All right. Nevertheless, the trial prosecutor was not aware of the existence of surveillance video bullshit in the Canton Police Department's Sallyport until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor. Prior to that, the prosecutor had not been alerted to its existence by investigating officers. But it is the prosecutor's responsibility to do their due diligence to see if there is any video footage and things that should be stored, and all of this should have been done by the prosecutor's office, if not by law enforcement. So promptly on April 4th, 2024, the Commonwealth provided the defendant with 9 surveillance videos in its possession. Trial started April 16th. So February, or I'm sorry, April 4th. Where did I get February? See, my brain just doesn't work today. April 4th, they get 9 new videos that they had never seen before, consisting of video footage of the main driveway of the Canton Police Station, and all these videos. These are the titles: O'Keefe, Sallyport. They all have different time stamps or time slots, so that's what those are. I'm not going to read them all, but there you have it. So notably, the quality of the video is poor in certain positions or portions, which that's we've noticed, but there's reasons why it's so poor also. In some areas, it seems to have been perhaps altered. So, notably, the quality of the video is poor in certain portions. However, that is the condition it was recorded in and the condition in which it was received by the prosecutor. The Commonwealth has produced evidence that since January 2022, the Sallyport camera was replaced due to its defective condition. Oh, okay. Due to its defective condition and during the first trial. So, wait. Oh, since January 2022. So, at some point in time, after January 2022 happened, they got a new, well, isn't that convenient? They got a new camera to say, like, oh, well, it was just defective. Commonwealth called the technology director up for the town of Canton to testify about surveillance video systems throughout the town, and he was subject to cross examination by the defense. Yeah, but they hadn't played that inverted portion yet. So how can you say that? Yes, the Commonwealth did call their technology director. I can't remember his name now, but and he was like, Adam Lally tried to hand him a disc, and he's like, I don't know what that is. That's not mine. I'm not touching that. Like, I don't take responsibility for whatever that is in your hand. And yeah, so bring him back. Maybe he might have something to say about the Sallyport video. We'd love to do some more cross examination now that we know that it recorded in reverse, apparently. Hmm? Let's do it. So the Commonwealth filed its certificate of compliance April 10th of 2024, noting that to the best of its knowledge and after reasonable inquiry, it had disclosed all information subject to Rule 14 um, statute that makes them turn everything over. The parties were in court on Friday, April 12th, to argue motions in limine during the defense's televised motion to admit third party culprit evidence. Attorney Yannetti made representations about the Canton Police Department's surveillance videos. Following that hearing on April 17th, Lieutenant Brian Tully sent prosecution team members an email stating, "I spoke with Chief Rafferty. She reviewed the video of the SUV arriving at the Canton Police Department exists and we should have it, contrary to what defense represented on Friday." So they're saying all of a sudden Chief Rafferty was giving evidence up just freely? Okay. The video depicts the vehicle entering the Sallyport and crime scene tape being put up. She is putting it on a thumb drive for us in the event that we don't have it. Okay. The prosecutor had not previously received this video or knew of its existence. Subsequently, the prosecutor requested that both the Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video. On April 23rd, 2024, the Commonwealth provided the defense with surveillance video entitled Interior Sallyport Back Wall. Notably, what was produced to the Commonwealth and provided to the defense was inverted surveillance footage due to the camera's settings. Sure. Commonwealth did not manipulate or alter any video and entered as a trial exhibit the video in the condition it was received. Contrary to the defendant's representation that the Commonwealth's intention was to mislead or deceive the jury by introducing inverted video, the defendant fails to mention that after the defense altered the evidence to correct the image to appear consistent with the human eye, the Commonwealth played the entirety of the corrected yet altered video, which reveals that Trooper Proctor is standing feet away from the defendant's vehicle and never touched the rear right light. What? Further omitted from the defendant's filing is the fact that Trooper Proctor's DNA was not on the rear taillight. Would you guys have turned that over if it was? I mean, come on. He's somehow saying that it the corrected video shows Trooper Proctor wasn't on the right taillight, never touched the taillight. BS. We know he was over there. We know. Because they tried to play it off like it was the left tail light, and they admitted, "Oh yeah, that's Trooper Proctor over there." Buchanan, I believe, testified to that. So after the trial, a certified forensic video technician employed by the Norfolk District Attorney's Office reviewed the surveillance footage that had been previously produced to the defense. Recognizing that the video was extremely dark with minimal visible detail, the video technician clarified the video footage, and on October 10th, 2024, the Commonwealth produced to the defense clarified video. So this is after trial, reports detailing the forensic clarification process and associated hash values and extracted still images from the Canton Police Sallyport. Furthermore, the video technician clarified video images from the Canton Police cruiser camera footage on January 29th at 8:23 a.m. Whose cruiser footage? The Canton Police Department interior Sallyport front wall footage from January 29th at 6:13 p.m. and the Massachusetts State Police Crime Scene Services section photographs from February 1st, 2022, each depicting the same damage to the rear right taillight and encapsulated those images in a substantive report provided to the defense. After trial on August 21st of last year, the Canton Police Department provided the Commonwealth with two additional videos. Video from the interior Sallyport camera on January 1st, 2022, depicting the camera captured all video in an inverted fashion to rebut the defense's suggestion that the video had been tampered with. All of a sudden, after trial, they turned over an inverted video from a different date just to prove, like, oh, look, it inverts other videos. That's not proof unless you have the metadata and the defense has a chance to also analyze and evaluate for that same occurrence to happen more than once. Or else, to me, that just shows that they did it on a different day. They just picked a random day and said, here, look, it always does this. We had nothing to do with it. That's my take on that. Hold on one second. Okay. All right, so they're playing some more dirty tricks here with turning over more inverted video. So it was in an inverted fashion to rebut the defense's suggestion that the video had been tampered with and consistent with witnesses' trial testimonies. Video from the interior hallway and exterior of the Canton Police Station that shows Brian Higgins at the Canton Police Station during the early hours of January 29th, 2022, and depicts Mr. Higgins moving his law enforcement vehicles due to the snowstorm. So they wanted they wanted to make sure that we all knew he actually did go there to move vehicles, I guess. He was drinking all night, so that's cool. Allow your ATF agent to drink all day and then, go back for an after party, do a little murdering, and then go to the Canton police station and move vehicles around and log in and out of, the Sallyport while there's evidence there from the incident that you were just at. Yeah, sounds legit. These videos were provided to the defense on October 10th, 2024, along with a letter from the Canton police chief noting their August 21st production. Prior to their production, the prosecutor was unaware of the existence. That is not an excuse. The prosecutor should have done everything in its power to get those videos turned over and should have assumed that there were video taken there and that they should have gone and gotten those in their possession with all metadata. The defense boldly claims that the surveillance video of Mr. Brian Higgins in and outside the Canton police station proves that he perjured himself before a federal grand jury. This claim is extremely prejudicial and false. In support of this claim, the defense cites to a federal grand jury transcript which is redacted. Further, the defense is unable to demonstrate any prejudice, and there's some more redactions there. Both Brian Higgins and Brian Albert were thoroughly cross examined at trial about their phone calls with one another. Additionally, the Commonwealth provided the defense with 167 pages of access card swipe records throughout the Canton Police Department on January 29th. Yeah, they looked at those card swipe records and they saw Mr. Higgins being being logged in and out of that Sallyport multiple times. Mr. Higgins was cross examined about his movements through the Canton Police Department on January 29th. Yes, but the defense was not able to ask about the whole conversation and who he was talking to that night at 1:30 in the morning because they didn't have it. They didn't have that evidence to impeach him with. On January 28th, 2025, the Commonwealth provided the defense with surveillance video from the main driveway side exterior Sallyport that depicts a different camera angle of the defendant's vehicle arriving at the Canton Police Station Sallyport. Notably, consistent with other videos received from the Canton Police Station Sallyport, the quality of video is poor. There is absolutely nothing depicted in this video that is exculpatory or undermines the consistent evidence that the defendant's right rear taillight was broken and pieces were missing prior to the vehicle being towed from Dighton. That's the point. There is no video available to depict her taillight at the time that it was being towed from Dighton. That's the whole point. Anything that represented her tail light, any video that might have captured it, any video that would have shown it in some form or fashion is destroyed, manipulated, timestamps flipped, image flipped. Uh, there's issues with all the videos except for John's ring camera where we see Karen's hitting his car and driving away. That one's the only one that we get to see of her footage, and the footage of Mr. Reed's home when the Dighton police were there to tow it. Those are the only two videos that we do have that depict her taillight. But all of the other videos that should have been collected, all of the photos that should have been taken for the purposes of investigating a pedestrian car incident, you should have been taking photos, videos, all of it should have been turned over to prove your case that she did it. But all of that just seems to be missing. That's just a little too convenient. But, anyways, prior to late January 2025, the prosecutors had never seen this video. After depicting a review of all physical and data files, this video was located within a paper case file of investigators. A paper case file of investigators. What does that even mean? After directing a review of all physical and electronic files, it should say, this video was located within a paper case file of investigators. That doesn't make any sense. What does that mean? After inquiry, it was learned that an investigator obtained this video from the Canton Police Department. Oh, okay. An investigator. Who? Just an investigator obtained this video from the Canton Police Department in 2022, and it was placed in a physical case file. How do you take a video and put it in a physical file? And never provided to the prosecutor or multimedia assistant for download. So someone has the original, this investigator supposedly has the original? Is that what they're trying to say now? Out of 3 years of litigation, they are saying, "Oh, look, we found the investigator now. Even though you've asked for this, it's been ordered by the judge, the court in this case, yet we're just now letting you know we found the investigator who has the actual file." Okay, cool. There's nothing suspicious about this whatsoever, right? I mean, I feel like, whew, they've got the right person here. Yeah, totally. Although the prosecutor was wholly unaware of this video until recently, the Commonwealth does not dispute that the video was in its custody during the defendant's first trial. So, yes, you can't dispute that because anything that is related to the investigation, law enforcement, anything that's in law enforcement's custody is also technically in the prosecutor's custody because whether the law enforcement turned it over or not, prosecutor has a responsibility to seek it out also. So there's some kind of, a reciprocal way of how the information is supposed to work between law enforcement and the prosecutors, and then the prosecutors are supposed to and then in turn give that to the defense, but that seems to get lost somewhere here. All right, so had the prosecutors known about this video, it would have been produced as every other video known to the prosecutor was. That's not an excuse. Ignorance is not an excuse, nor is it a way out of maybe some punishment, perhaps. Adam Lally and Laura McLaughlin, and maybe Brennan too. I mean, it doesn't negate the fact that there was some misconduct here by the prosecution. So, even in circumstances where the prosecutor fails to disclose evidence a defendant is entitled to receive, there must be a showing of irremediable harm to the defendant. This court must examine the extent to which the defendant was disadvantaged in defending herself when considering the prejudicial quality of exculpatory material evidence. In measuring prejudice, it is the consequences of the delay that matter, not the likely impact of the non disclosed evidence, and we ask whether the prosecution's disclosure was sufficiently timely to allow the defendant to make effective use of the evidence in preparing and presenting his case. I don't know what that has to do with this. That was kind of a long winded, non relevant statement there. The defendant cannot show irremediable harm to her right to a fair trial as it relates to the Canton Police Department surveillance video. How? What do you mean? She didn't have the video of the Sallyport turned over. It was late. It was turned over mid trial. It was inverted. Like, there's so many things wrong with the video that have prejudiced her. Yet, I don't know how we're still here arguing about it. While the January 28th, 2025 production was untimely, the poor quality of the video makes it difficult for either party to benefit from. Furthermore, this video depicts the same event that was contained on the surveillance videos produced on the 4th of April, the 23rd of April, simply just from a different camera angle. Further, well, that doesn't matter. They all should have been turned over at the same time. Like, why are we still getting piecemeal discovery of the Sallyport photo or videos? Further, while the Commonwealth would argue that the videos from the Canton Police Station Sallyport are inculpatory, the defendant benefited during the first trial by suggesting, without any substantive evidence, that the poor quality of video and/or gaps in time due to an improperly functioning camera system were caused by an improper police investigation and systemic police misconduct. Whatever, Hank. I can't even argue anymore. He's wrong just on so many things. You wrong, Hank. In November 2024, the defense made an informal discovery request relative to Canton Police Department videos. The Commonwealth and Canton Police Department facilitated the request, and on December 12th of last year, in the presence of the defendant's expert, it was discovered nearly 3 years after the incident that the footage of the DVR was overwritten. Yeah, okay, you discovered it just then. My butt. I don't believe that for a second. I think you knew it was overwritten. I think it might have even been deleted off the system, if you ask me, but that's neither here nor there. All right, so that the footage on the DVR was overwritten and the system no longer maintained the original surveillance footage to be forensically extracted. So, if you recall, Karen Reed had one of her experts fly out. I mean, this was prearranged by the defense, by the contacts there at the Canton Police Department. This was prearranged. Her her expert was going to fly out there, do this data extraction, do his, forensic analysis and whatnot, and let us know if the Sallyport video had been manipulated or if it was an original and that's just how it recorded. But guess what? He wasn't able to do that because, oh, yeah, the DVR system was overwritten over 30 days, after 30 days, everything overwrites, which just happens to be a convenient setting for police department, even though they might have evidence and things that they're bringing into that Sallyport. I guess they didn't think about that. So there's that. All right, so this also marked the first time that the defense had made any request for metadata or logs pertaining to these videos. Bullshit. They've been asking for this stuff for years, man. As neither the defense's February 2nd nor October 5th motions or corresponding orders make any reference to such materials. And here they're quoting Commonwealth versus Williams. A defendant who seeks relief from the loss of destruction of potentially exculpatory evidence has the initial burden to establish a reasonable possibility based on concrete evidence rather than a fertile imagination, and access to the lost or destroyed evidence would have produced evidence favorable to his defense. So they're trying to throw this in here saying it's just Karen Reed's imagination that the CPD are doing things to her evidence there. It's just an imagination, that's all. If he meets his initial burden, a balancing test is employed to determine the appropriateness and extent of remedial action. The courts must weigh the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant. All right, so here the defendant fails to meet her initial burden. She has presented absolutely no evidence that a forensic copy of the Sallyport surveillance video with metadata and logs would have been exculpatory. Rather, she relies upon innuendos and unsupported allegations that are speculative at best and not the equivalent of concrete evidence. However, when is something so egregious as this, usually you would dismiss the case, but in this instant, Canoni's probably not going to do that. So there should be at least some other remedy. Some judges might, not dismiss the case, but allow, some kind of curative instruction that might say something about, like, you might be able to infer the fact that all of this evidence is missing. You can infer that it would have helped the defendant and that it is damaging to the prosecution's side of their case. So that kind of instruction is given all the time. Will Canoni give it? I think no. But that is just something that, is another thing that could be done in this case, is some kind of instruction. And that's another point of what I was trying to make, was that it is okay to make that inference that the absence of something, especially like in this case when there's so much absence of this one thing and so many problems with this one thing, it can be construed that, maybe there was something nefarious going on, or maybe there was some misdeeds happening. All right, moving on. Even if this court was to engage in a balancing test, dismissal would be inappropriate, and there is no evidence of egregious misconduct on the part of the Commonwealth. baloney. There's been so much, but anyways, and any potential prejudice stemming from the overwritten videos could be remedied at trial. So he's saying it's too much of a punishment to completely dismiss the case for the Commonwealth. So we can do some kind of remedy at trial, like I said, some kind of curative instruction or something. The court must consider the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant. So uh, he's claiming no responsibility, which, as you know, even if they knew about it or not, it was still their responsibility to find out about it. The defendant can point to no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved. Okay, so the Commonwealth is also handicapped by this poor video quality and inability to obtain this forensically extracted copy because you know what? It would help our case. So we're equally hurt by not having this evidence. Really? Really? That's his argument. That's what he's going with. Okay, cool. Statement of Jennifer McCabe. In violation of the defense's discovery order to produce all reciprocal discovery, including impeachment evidence, to the Commonwealth prior to the start of the trial, it was during the trial week, during the third week of trial, on May 7th, 2024, that the defense produced reciprocal discovery to the Commonwealth regarding location information of Jennifer McCabe's cell phone. 3 days later, on May 10th, 2024, in anticipation of her trial testimony, the Commonwealth met with Jennifer McCabe as it does with all its witnesses. Right before she was about to go on the stand. 3 days later, it says, when did she go on the stand? I don't know. But she had this meeting shortly before she went on the stand. On May 29th, Lieutenant Tully wrote a police report memorializing that meeting and explained, when asked why her cell phone would have been in the area of the residence of Sergeant Michael Lank on January 30th, Jennifer McCabe stated that she was with Carrie Roberts, who was picking up her daughter at the residence. We also learned that there's some inconsistencies in these statements. Jennifer did not speak with Michael Lank while at the residence, according to Lieutenant Tully's notes. However, Jennifer McCabe first said that she wasn't in the area, and when he questioned her about it, why her cell phone would have been in the area, then she stated, oh, Carrie was picking up her daughter, Carrie Roberts. But then she says later in a statement, she's inconsistent and says Carrie was dropping her daughter off. So there's three inconsistencies in that one conversation with uh, Lieutenant Tully. The Commonwealth produced Lieutenant Tully's report on Monday, June 3rd, 2024. We've got a footnote here. It says, at the request of the defense, the trial was suspended on Wednesday, May 29th, Thursday, May 30th, and Friday, May 31st. I don't recall that. On June 18th, 2024, in response to the same claim raised by the defense, the prosecutor explained to the court that Ms. McCabe met with Lieutenant Tully, looked at some video, and was asked a single question. That report wasn't available. I didn't have it until after Ms. McCabe testified, but it was given to counsel prior to Lieutenant Tully testifying. On May  21st, 2024, Attorney Jackson vigorously cross-examined Ms. McCabe, and she details her reasons for being in the driveway of Sergeant Lank's home on January 30th. During cross examination, Attorney Jackson elicited testimony that it was Lieutenant Tully who asked Ms. McCabe an open-ended question of, "Did you go to Michael Link's on January 30th?" Attorney Jackson then questioned Ms. McCabe about whether there were any follow-up questions or whether the Commonwealth revealed the defense's report. Ms. McCabe testified that neither occurred. Did she? But she did communicate with, she communicated with Tully, Lolly, Ms. McLaughlin, all about um, that incident. Notably, the Commonwealth produced Lieutenant Tully's report once it was available to the defense prior to Lieutenant Tully's testimony. Lieutenant Tully was available to be cross-examined about his recent meeting with Jennifer McCabe and or any perceived inadequacies in the investigation related to Ms. McCabe's phone's whereabouts. The defense declined to do so. Furthermore, on May 22nd, Carrie Roberts testified. Ms. McCabe had testified one day prior that she had accompanied Ms. Roberts to Sergeant Link's driveway. The defense relinquished their opportunity to cross examine Ms. Roberts, which I think now was a mistake, but I think Carrie Roberts has been a much bigger part in this than we've all been led to believe. I think she has a much bigger role in gaslighting all of us and lying on the stand. The defense relinquished their opportunity to cross examine Ms. Roberts about the event at Sergeant Link's house, let alone ask her one of only a few recipient witnesses a single question. So maybe they felt that they didn't need to at the time. However, most enlightening on the defendant's lack of prejudice is that on June 18th, Attorney Jackson stated during trial they, meaning the Commonwealth, interviewed Jen McCabe, apparently had a full interview with her. Lieutenant Tully took a report, dated the report, and then the Commonwealth held on to that report until after she testified. The interview, the report, and the completion of the report were all done before her testimony. Immediately, the court offered, do you need to call her again?" Attorney Jackson responded, "No, Your Honor, I'm not. That's not, and I think the court understands that's not my point. My point is not that I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe." The court says, "I'm sorry, I missed that. You've what?" Attorney Jackson says, "I've done the damage that needed to be done on Jennifer McCabe. I don't need to call her back." When given the opportunity to remedy any perceived prejudice, the defense declined to do so. I don't know if that really proves Hank's point there, but okay. The trial court, security, and jury dismissal. And here we might get a little more insight as to what the defense's filing had to do with regarding dismissing that jury members or member. I don't know, but what was going on? There's something going on. The defendants claim that a lieutenant of the Massachusetts State Police, well, that would be Lieutenant John Fanning, was in charge of jury security, and that is patently false, according to Hank. At no time did Lieutenant Fanning have contact with nor control or influence over the trial jury, nor was there any jury tampering that deprived Ms. Reed of her constitutional right to a fair trial. The defense's brazen misrepresentation. Okay. Okay, you're going to talk about misrepresentations, Hank? We just had a whole hearing, and Robert Alessi had to go in there defending the defense attorneys because of some of your own misrepresentation. So you want to go there with misrepresenting things brazenly? The defense's brazen misrepresentation, previously proffered in media interviews, in direct violation of the impoundment order of juror discussions and sidebars, solely to mislead the public and jeopardize the integrity of the judicial proceedings, are false and dishonest representation. We have a footnote here. Says on February 17th, 2025, Boston 25 News aired an interview with the defendant and Attorney Jackson, where Attorney Jackson stated that Lieutenant Fanning was the very person governing the jury. Jackson also stated, despite representations in this court filing, that he had no specific evidence of jury tampering. Well, you know what? Maybe he wasn't going to be putting that all out, the things that he was going to be putting in his motion to dismiss all out on, public airways. So maybe he didn't want to show his cards before it was time. So the executive branch of government is separate and distinct from the judiciary. The governance of the jury is solely within the power of the trial court and sworn court officers. The defendant's first trial raised significant safety concerns for both parties, members of the victim's family, witnesses, court staff, media, and the public. Okay. Significant safety concerns. Get out of here with that for all these people. No, the biggest significant safety concern was the blue shirts that showed up like the last 2 days of deliberations or whatever it was. Those were the biggest safety risks. And any dangerous type of people that were there that like the reporter or whatever you want to call him, Grant Smith Ellis, who was assaulting Jessica Machado, another reporter. That was a safety public concern. He got uh, what's the word? A protective order against him. Other people, safety concerns were, the Kate Peter, who has been stalking and trying to disparage and defame Turtle Boy for years. She was there in the presence of Turtle Boy, who also has a restraining order against her. So, and other things that, the blue side, what they were doing was the only safety concerns I saw during trial. But anyways, to effectuate both the defendant and Commonwealth's rights to a fair trial, this court ordered a buffer zone around the courthouse. What does this even have to do? To enforce the buffer zone and maintain order, approximately 50 uniformed officers from the Massachusetts State Police and other local departments were deployed each day on foot, motorcycle, and bike in the area directly surrounding the courthouse. Additional law enforcement resources were available in proximity to the courthouse at the Dedham Police Station. As a superior officer assigned to the Norfolk District Attorney's Detective Unit, and the only supervisor who was not a trial witness, Lieutenant Fanning was one of the commanding officers who was involved in the safety and peacekeeping efforts occurring outside the courthouse. So here I think this is one of the first lies that he says about Fanning, because Fanning was never outside. He was never there, not once. No one ever saw him. Turtle Boy reported this on his X page today. He was there every day. Lieutenant Fanning was not once seen outside Dedham Courthouse because, or the Norfolk Courthouse, Norfolk Superior Courthouse. He was never there. So I think this is a blatant lie there. Yet, somehow, the defense conflates the fact to misrepresent that Lieutenant Fanning therefore improperly influenced and tampered with the jury. To do so, the defense omits the remainder of Assistant District Attorney McLaughlin's statement to the court. And we won't know what ADA McLaughlin said because it is redacted. However, conveniently omitted from the defense's filing and extrajudicial statements is the following from ADA McLaughlin, also redacted. At no time did Lieutenant Fanning enter the Norfolk Superior Courthouse during the defendant's trial. Moreover, he never saw, let alone spoke, to any member of the jury. Furthermore, there is absolutely no evidence that the dismissal of the juror was improper. Well, maybe, maybe not. But whether Lieutenant Fanning ever entered, so you're saying he was there every day, but he just never entered the courthouse. Okay. Maybe I believe that, but I don't. Um, but yeah, and then there was a big redacted portion there. But they're saying that he never spoke to or saw the jury members. Well, he doesn't need to. He was overseeing them. He was placed in charge of overseeing them by Judge Canoni, if I am not mistaken, because it is her responsibility to assign her court officers or whoever she wants to assign. Apparently, people who have a conflict of interest in the case, she can assign to oversee the jury. And so that means he had all of the information on their background checks, all of their private information. He knew, he had court officers and other people there that possibly reporting to him. So he didn't need to actually be there. He could have had people reporting to him about what was happening. So he didn't need to be there. The defendant's preposterous claim, one that Attorney Jackson has stated he had no specific evidence of, should be rejected outright. Conclusion. In sum, the defendant's motion should be denied. Okay, so he said in a public um, format in front of the media, which you expect that they're not going to give away their case strategy and whatnot in front of, in a public forum like that before they put it in a filing. So why on God's green earth would Attorney Jackson say on that in that and who knows when they recorded that interview, by the way, for Boston 25, but it's not, unheard of that he might say, well, no, we don't have specific evidence, even if he does. So I'm not worried about what he said in a Boston 25 interview, but he's putting so much weight on these media interviews that it's like they're being sworn under oath, but it's not the same. That's not under the same scrutiny. You're not being sworn under oath. So why on earth is he like caring so much about these media interviews, which he's watching? So there's that. All right, so he says in sum, the defendant's motion should be denied. The defendant can show no irremediable prejudice to her right to a fair trial, nor has the evidence in good faith shown that the Commonwealth engaged in prosecutorial misconduct. Presumptive prejudice warrants dismissal to prevent repetition of misconduct. Dismissal of the case is accordingly not appropriate. Further, where the defense's claims do not raise any substantial issues, the request for an evidentiary hearing should be denied. So they don't even want a hearing to take place where the defense can call Adam Lally, Laura McLaughlin, other certain people, John Fanning, maybe some jurors, perhaps. I don't know. They might be able, well, I don't know if Judge Canoni would let them do that with that whole rule where you can't talk to jurors, but there are plenty of people that they can call to talk about this jury stuff. All right, so I was going to say something else, and now I can't remember. Oh, this whole presumptive prejudice warrants dismissal to prevent repetition. So I don't know why he put that there because that only proves the defense's point that there's so much. Well, he's saying that there's not, I guess, not enough prejudice to warrant a dismissal, but there's so much prejudice against the defendant based on their motion to dismiss, and it definitely does warrant a dismissal. But this is saying um, you don't want a repetition of this misconduct. So there could be a possibility that without dismissing it, she might throw the whole prosecution team off if she feels inclined to. I don't think she's going to do that, but she has the option to do that because uh, they're not playing by the rules. So, will she do that? No, but it's a possible option that she could do. But all of this is going to get denied anyways, so what are we talking about? Because this is Judge Canoni we're talking about here. All right, so lastly is the Commonwealth's affidavit in support of their opposition to the motion for uh, motion for dismissal. He says, "My name is Hank. I'm a special prosecutor and lead attorney. I entered my appearance October 24th. My name is Adam Lally." So Lolly's on here. So all of the whatchamahoots, the prosecution team are on here. Adam Lolly's on here and Laura McLaughlin's on here. She's appellate counsel appearing in this case. Okay. So that is her main role, I guess, is appellate counsel for the Commonwealth. So why she was there the first try, I don't know. But anyways. All right. So on June 9th, 2022, the defendant was indicted by a Norfolk grand jury for second-degree homicide, manslaughter while operating under the influence, and leaving the scene of personal injury or death. On April 16th, a 10-week jury trial commenced, with Beverly Canoni presiding. In addition to the 3 indictments, the jury was instructed to consider 2 lesser included offenses to manslaughter while operating under the influence: 1, involuntary manslaughter, and 2, motor vehicle homicide, OUI, liquor, and negligence in violation of the statute. So those are the 2 lessers of the manslaughter charge and the greater manslaughter charge, and they were not able to come up with any kind of determination or verdict on that. On July 1st, 2024, upon finding that the jury was deadlocked, the court discharged the jury and declared a mistrial. The defendant's second trial is scheduled to begin on April 1st, 2025. I reviewed the Commonwealth response to the defendant's motion to dismiss for extraordinary governmental misconduct. The statements contained within are a fair and accurate understanding of the materials received and produced to the defense. So I don't know what this is trying to prove. This doesn't prove that they're not conducting themselves improperly. This doesn't prove anything. Basically, they're just saying that everything that they said in the Commonwealth's response is fair and accurate. Well, okay, but your word is nothing now. So there's that. Their word is as good as nothing because close all of these. We're done. Yeah, I don't trust anything that Hank says, anything that comes from the Commonwealth nowadays. I don't trust, especially after Hank's horrendous display of trying to get Alan Jackson kicked off the defense and possibly even Yannetti. So pretty underhanded and dirty. And I do, I can't believe I've actually gone back and like started watching some of the pretrial hearings all over again just kind of, now that we know so much that we know, I was kind of just curious to see what, you know, if there's anything that's glaringly sticking out at me or whatever, but it's clear, man. I was right about Canody from the beginning. She's always been biased and rude to the defense, and it's gotten progressively worse, but she's always been that way. She's always been really rude to the defense. So, I don't know. It's going to be interesting to see how this goes forward. It's going to be interesting to see what the next steps are because with this motion to dismiss, now what's Bev going to do? And also, feds, what are they going to do? I mean, I'm not talking about the federal investigation. That's another thing that I don't even want to get into, but mainstream media has been reporting that it is, that the federal investigation is confirmed to be over by unconfirmed sources. I don't buy it. I don't believe it for a second. I don't think that the federal investigators are just going to be like, you know what? Your investigation is over and we're not going to arrest you. No, they're not going to do that. So that's just